This is Bloomberg Law with June Grasso from Bloomberg Radio.
I want a broadcast network. I want to see what other news operations we can sweep up.
He's erratic. He's making bad decisions. If he's not careful, he's going to destroy the company.
Emily, you going to do something?
I think I'm the best option.
Oh, right, because you like playing boss?
Kick out the old man, in with the new guard.
You want this enough to go to war with your family.
It's rebellion, sabotage, deliberate attempt to undermine my whole business. It's my company.
It's a bitter legal fight among siblings over a media empire that's reminiscent of the TV series Succession. With good reason, since that show was inspired in part by the Murdochs. The Murdoch succession battle playing out in Nevada is over an irrevocable family trust that will ultimately decide who controls the conservative media empire that includes Fox News and the Wall Street Journal. Rupert Murdoch is trying to change the terms of the irrevocable family trust created in 1999, which splits his voting shares equally among his 4 oldest children after his death. The 93-year-old wants to alter it so that all his voting shares go to his eldest son, Lachlan, the CEO of Fox and chairman of News Corp, who's politically aligned with him. That prompted the 3 other children to fight back in probate court. Joining me is Jamar Creech of Romano Law. First of all, why is this in Nevada?
This is in Nevada because Nevada offers a number of protections for trusts, including privacy, flexibility, management, and asset protection. So the trust laws in Nevada are just very, very favorable for situations like this.
It's in probate court. Several news outlets tried unsuccessfully to open up the proceedings. Is probate court ever open to the public? Is it always closed?
Well, in this instance, this is not really a probate matter in a traditional sense because Rupert Murdoch is still living, but this is a dispute regarding the structure of an irrevocable trust. So in instances like this, in some jurisdictions, those matters are more publicized, but because of Nevada's laws and structure, this is a more private matter, which would include things like, in addition to the just regular Nevada laws, things like non-disclosure agreements and such would all provide kind of those walls of protection for privacy.
So explain what the issue is.
Certainly. So Rupert Murdoch established many years ago an irrevocable trust, which provides in part for the management of his assets upon his death, which would include Fox Corporation and News Corporation. And in that trust, he lists 4 of his 6 children as the individuals who will be able to take control over those assets: James, Lachlan, Elizabeth, and Prudence. And right now, as many people know, Lachlan Murdoch was named CEO of Fox and chairman of News Corporation. And Rupert Murdoch is attempting to change that trust and give Lachlan Murdoch controlling interest over all those assets, as opposed to equal authority as it's currently written.
So you mentioned that it's an irrevocable trust. If it's irrevocable, how is he allowed to change it?
Great question. The law provides in certain instances, so long as the changes are in the interest or best interest of the beneficiaries and the changes are made in good faith, changes can be done to an irrevocable trust. But it's a high standard. In most instances, changes are not permitted.
This irrevocable trust was set up as part of a divorce settlement with his second wife. So if it's changed, does that invalidate the divorce settlement in any respect? Because giving all the voting shares to Lachlan was not what was agreed to.
Yeah, that's a possibility. I mean, without seeing the settlement terms of the divorce as well as the actual trust itself, I imagine this was, as you indicated, some consideration for the divorce. And it's likely that if, in fact, these material alterations to the trust are permitted, that could be affected as a result.
Explain what Rupert Murdoch is arguing, why he says it's in the best interests of his children, as far as we know.
Sure, and I'm glad you asked me that question because there has been limited coverage on this. So as far as I understand, Lachlan Murdoch, who's currently, as I indicated before, the CEO and chairman of Fox Corporation, News Corporation, respectively, his political stance is aligned with his father. And Rupert Murdoch believes that this is part of the reason why he should be able to continue on running Fox and News Corporation, because the success is based principally on, or in part, on the political ideologies of Fox Corporation, and any changes to that could significantly change the value of these assets that are currently in the trust.
How does a judge decide, oh, in years to come, this may change if this happens? I mean, that seems like it's so speculative.
Yes, it is. Forecasting something like this is just hard to do. I think that will likely be the avenue that Rupert Murdoch is going to have to take in order to demonstrate that this is in the best interest. But a judge is going to rely on, I would imagine, past performance. And, I mean, there are experts out here who can provide these types of projections. So with the long history of Fox and News Corporation and the current performance of these assets, these corporations, an expert can give a reasonable future value of what these companies may be able to do moving forward.
Is it more about politics than about future benefits to his children, that Rupert Murdoch wants to keep Fox and the rest of his media empire conservative?
Yes, that's correct. That's why Lachlan has been tapped as the successor. The other children, James, Elizabeth, and Prudence, they don't share those, as I understand it, they don't share those same political positions. So the future of these entities could be in jeopardy, if you will, from perhaps Rupert Murdoch's position if Lachlan is not given the controlling interest.
The three children have united. They have one lawyer. They say, reportedly, that the move violates the spirit of the initial trust enshrined in its equal governance provision.
Their argument is that the original intent of the trust was to provide all of them with equal authority to manage these corporations, these assets moving forward. So significantly altering that changes the original intent and also impacts their interest greatly. And that's not what was thought of when this was created, and that should not be permitted here because that would not be in their best interest. And quite frankly, not in good faith either.
Well, I mean, it does seem that no matter what they say about how Fox will perform, that it's not in their best interests to lose control of the companies. I don't think this is about money. Each of the 6 kids are multi-billionaires.
Correct. I agree with that 100%. I mean, there are a couple of things at play here. One, there's the actual future value and performance of Fox, which Rupert Murdoch is likely going to argue as the basis for wanting these changes. On the other hand, the children themselves, while that may be a consideration, their primary interest is keeping their interest, if you will, intact under the trust. So the performance is really not, as you indicated, not their main concern. It's, I have a piece of the rock, if you will, and I want to maintain my piece of the rock.
So the probate commissioner will make a decision, and then that can be appealed to the district court, and then that could be appealed to the Nevada Supreme Court. So this could take years.
It could. It just really depends on how this plays out. But yes, I mean, in theory, it could take years because, to be quite frank, given what's at stake, the control of the Wall Street Journal, the control of Fox and HarperCollins and all of these massive entities, yes, that could very well happen.
So what happens if Rupert Murdoch dies before this is resolved? Then the trust would go into effect at that point, right? So is this attempt to revoke the trust over then?
If he dies, then the trust has to be construed as it is. Now, there could still be some issues to resolve moving forward, but it now turns into, as you indicated before, a matter of administering the trust. I mean, it's the probate matter at that point, and the trust will have to proceed as is. There are, in most trusts, successor trustees. So in the event that Rupert Murdoch dies, the successor trustee would then be charged with administering the trust. But in most instances, the successor trustee does not have the authority to alter the trust because the successor trustee did not create it. Their only function is to carry out the terms of the trust as drafted.
Does it happen often that, people want to change the irrevocable trust, not the beneficiary, but the person who set it up?
Does it happen often? It's hard to say. What I do feel, in some instances, given the nature of the matter before the Nevada commissioner, is that there are assets that are trying to be protected here, and this seems to be more like an instance where Rupert Murdoch is looking to manage his assets perhaps from the grave. So if someone feels like, hey, I'm not going to let my vision of what I've built, if you will, get changed or significantly altered, then yes, I'm going to crack open this irrevocable trust and make the changes in a way I see fit.
If that's what's really happening, that's not the argument that you need to change the irrevocable trust, because that's not in the best interests of the beneficiaries.
Not at all.
So the next thing is that the commissioner will make a ruling, and we may not hear about that for a while because it's not a public record. Thanks for being on the show, Jamar. That's Jamar Creech of Romano Law. Coming up next on the Bloomberg Law Show, new lawsuits are testing the power of a string of federal agencies as companies take their cues from the Supreme Court's decisions. This is Bloomberg. The Federal Trade Commission, the Occupational Safety and Health Administration, the National Labor Relations Board, and the Equal Employment Opportunity Commission. These are just some of the agencies that have been targeted in recent months in a challenge to federal agency power. These challenges will test the limits of recent Supreme Court decisions that roll back the power of federal agencies to regulate business and overturned a 40-year-old legal precedent that had been a regulatory bedrock. Some conservatives have their eyes on a 1935 Supreme Court decision, Humphrey's Executor versus the United States. It established removal protections for FTC commissioners and helped lay the foundation for the modern administrative state. Joining me is an administrative law expert, Cary Coglianese, a professor at the University of Pennsylvania Law School. There are so many agencies that are being sued right now. Is it just a general attack on agency power, or is it more specific?
Well, there's both a general attack and a specific but broad attack on agencies that we would call independent agencies, meaning that they've been set up so that the heads of these agencies can't be fired at will by the president. And there's a big target on a 1935 precedent of the Supreme Court that upheld these so-called good cause limitations on removal of agency heads. And pretty much any agency with those good cause limitations are, in either you call it the spotlight or the firing range. I don't know what's the better metaphor these days. But yes, we're seeing a lot of it.
So let's talk about some of them. There is one against OSHA's Review Commission. So Kenrick Steele sued on September 17th to block enforcement of a $348,000 safety fine against it. But it's not so much about the fine itself. It's arguing about process and attacking the structure of the agency.
Right, exactly. And strikingly, this review commission and its structure, which is mainly an adjudicatory structure that reviews violations that are alleged by the Occupational Safety and Health Administration that have been upheld by the Supreme Court in the past. But, precedent by the Supreme Court today, I don't know, that and maybe $3 at Starbucks gets you a cup of coffee.
So true. So explain what they're attacking specifically here.
Sure. So it helps to go back to really square one and just recognize that we have, in the Constitution, 3 branches of government. Article 1's the legislative branch with Congress. Article 2 is the executive branch headed by the president. Article 3 is the judiciary. And we have a system of what's called separation of powers, but also one of checks and balances where the different branches of government have different kinds of oversight or involvement of other branches. Now, what we don't see in the Constitution is an Occupational Safety and Health Administration or a Federal Trade Commission or so forth, right? So those are departments or agencies that the Constitution actually acknowledges and contemplates that they will exist. There are references to departments and agencies, and in fact, there's a provision that speaks to how the heads of these agencies or departments will be appointed, but these are agencies set up by Congress, by statutes. And there's a process, of course, by statutes with the separation of powers where Congress passes laws, the president signs it. So there's like two branches of government in creating a law. These agencies, as I say, the appointments of the heads of them is governed by a pretty clear procedure in the Constitution itself, but the Constitution is totally silent about how they can be removed, the heads of these agencies. And that, for the longest time, had been kind of settled law that for purely executive agencies, the ones that would just be executing laws through ministerial functions, purely executive actions. Maybe law enforcement might be thought of as even one of those. The courts had said, since a 1926 decision by the Supreme Court, Myers versus the United States, those had to be capable of being removed. The heads of those agencies had to be capable of being removed by the president at will, meaning for any reason, the president could remove them. But Congress could, according to a 1935 decision called Humphrey's Executor, case involving the Federal Trade Commission, Congress could impose what are called good cause limitations, which limit the president's ability to remove the heads of those agencies to those instances where there's good cause. Usually that refers to things like negligence, dereliction of duty, criminal offenses, gross violations of carrying out their functions. And these good cause limitations have been placed in statutes limiting the president's ability to remove certain agency heads than just for political reasons, just because, say, the heads of these agencies don't do the president's bidding. That's not a good cause. So that's been the law since 1935, Humphrey's Executor, and the Humphrey's Executor decision now is really under some threat of being overturned, much like the Supreme Court has overturned Roe versus Wade, much as it has overturned Chevron versus Natural Resource Defense Council, a 40-year precedent. There's a likelihood that there's a majority on the court that would be willing to overturn Humphrey's Executor. And we know that because the court has been, since at least 2010, so at least for the last 15 years, slowly chipping away at Congress's ability to put in place these good cause limitations on removal of officers in various cases.
So tell us about the line of cases sort of chipping away at agency power.
There's not been a sort of a wholesale frontal challenge to all of these good cause limitations. In 2010, the court said, well, Congress can't put good cause limitations on an officer that can be removed only by another officer, a higher officer that has a good cause limitation. So no double layer of good cause limitations. In a case in 2020, Celia Law versus the Consumer Financial Protection Bureau, the court said you can't have a good cause limitation on agencies that are headed by just a single administrator. But that still leaves agencies like the Federal Trade Commission, like the Federal Communications Commission, like the Occupational Safety and Health Review Commission, like the Consumer Product Safety Commission, like the Federal Reserve Board, where there are multi-members that head up these commissions that have good cause limitations. Those are still in place as long as Humphrey's Executor is still in place. But, it's anybody's guess how long Humphrey's Executor will stay law, and all sorts of litigants are trying to challenge Humphrey's Executor frontally by these current lawsuits that you're seeing.
Let me ask you a basic question. isn't it better to have an agency head where the president can only remove for good cause? Because then the agency head is not so much subject to, shifting political winds.
I mean, there's good arguments, policy arguments for that, and certainly there's really strong research, for example, that shows that central bank institutions around the world that are somewhat insulated from politics are better for the economy. So, there's a lot to be said for that. And even, quite frankly, with agencies where the heads can be removed by the president for any reason, there's still a good argument that we would want these agency heads to exercise autonomy from the pure, raw electoral politics and do what is best for the country in carrying out their statutory mandates. So I think you do see many presidents recognizing that, and you see even instances where it could be possible for a president to remove an officer who might be creating some kind of embarrassing or perhaps slightly electorally disadvantageous decision, keeps from removing them because they recognize the value of that autonomy. You think about a very special counsel that was investigating President Biden for his retention of documents that were deemed classified, for example. That was handled by a separate process that's structured through regulation, but the president didn't intervene and say, I want to get rid of that. There's recognition, I think, on both sides of the aisle, historically, that certain agencies do need to exercise autonomy. Do we want a Food and Drug Administration that's making decisions about the safety and efficacy of our medications or medical devices based upon the whims of a non-expert president or what seems politically desirable or expedient for that president? I think most Americans would say no. We want the expertise, we want the independence and the autonomy.
Coming up next on the Bloomberg Law Show, will the Supreme Court overturn the unanimous ruling in a case that helped lay the foundation for the modern administrative state? I'm June Grasso, and you're listening to Bloomberg. A host of federal agencies have been targeted in recent lawsuits in a challenge to agency power, testing the limits of recent Supreme Court decisions that roll back the power of federal agencies to regulate business. I've been talking to Professor Cary Coglianese of the University of Pennsylvania Law School. I can understand why the Supreme Court last term and increasingly is giving more power to judges. But I don't understand why they're giving more power to the president. I mean, even in that controversial case, they recognize certain presidential immunity from criminal prosecution. Why is that a conservative viewpoint to give more power to one person?
Well, that's a really good question. I suppose you might have to ask, those that are espousing this. And to be fair, I mean, we don't yet know if there's a majority that would overturn Humphrey's executor. You'd have to ask, justices who've been on the record as criticizing it, like Justice Gorsuch or Justice Thomas, and see what they say. But over the last couple of decades, there's emerged a real preference in conservative legal circles for what's called the unitary executive theory that puts the entire federal government under the president's control. They're very control, top-heavy, hierarchically control orientation in their approach under this unitary executive theory. And, maybe partly it's because, Republicans have been more successful at putting their, candidates in the White House than they might otherwise be in getting, majorities in Congress to pass laws that would implement their agenda. I don't know. But this grows out of this real preference as of late for a unitary executive. And the limitations on the president's power to remove is seen as really central to that theory, because this is true, I suppose, in almost any employment situation. how can a boss, run an organization if ultimately the boss can't fire somebody who's unwilling to follow directions?
If they do away with Humphrey's executor, what would that actually mean?
What it would just mean is that the heads of agencies that are currently deemed to be independent are now removable at will by the president. So it might not change a lot. I mean, we look at, for example, what's happened after the Celia Law versus this Consumer Financial Protection Bureau case in 2020. Now there's the ability of a president to remove the head of the CFPB at will. But here's the thing. The heads of these agencies are usually aligned with the president. The president appoints them. That goes through Senate confirmation, and there's, often a great deal of alignment. So in many cases, there's not going to be much of a difference. Now, I do think there could be a big difference if we have another Trump administration. This was a president who in the past, has been willing to fire at will heads of agencies like the head of the Federal Bureau of Investigation, that other presidents in the past have said, we should leave the FBI alone and let them have that autonomy to conduct investigations and not meddle politically in them. Let's just be clear, the Food and Drug Administration is an agency that's not independent, that the head of it could be removed at will by the president for any reason. But most presidents recognize that, first of all, they put in place a competent FDA administrator and they let them do their job. And unless they do something absolutely wildly irresponsible, you let them do their job. President Trump, however, would be, I think, more than willing to intervene with some of these agency heads.
Humphrey's executor would affect every kind of agency, not just...
It's the president. Yeah, I mean, it's one of these things, of course, it depends on exactly how the court would decide to deal with Humphrey's executor. So far, it's been nibbling around the edges, and it says, well, Humphrey's executor said these good cause limitations could apply across the board to any agency that exercised what it called quasi-legislative or quasi-judicial functions, which is just about any agency. Well, then we got this little carve-out for the double layer of protections in 2010 for the Public Company Accounting Oversight Board. Then we got this little carve-out from Humphrey's executor clear rule in Celia Law that says, well, no, that you can't have good cause limitations when there's a single agency administrator. But we haven't yet had the full, frontal repudiation of Humphrey's executor. Maybe there's going to be a way for the Supreme Court to say Humphrey's executor is overruled for anything except the Federal Reserve, perhaps. That's a possibility. It wouldn't seem to be a principled carve-out, but, the Supreme Court gets to set the final word. So if they want to carve out the Constitution in a way that protects monetary policy, that would be better than eliminating Humphrey's executor altogether. But it's just hard for anyone right now to imagine how they could do that on a principled basis.
I'm trying to count justices here because there was a concurring opinion by Justice Kagan that was joined by Justices Sonia Sotomayor, Brett Kavanaugh, and Amy Coney Barrett that people say signal that maybe they wouldn't go along with a wholesale doing away with Humphrey's executor. And I'm trying to count how many. We know that Clarence Thomas and Neil Gorsuch and Alito,
right. And we don't know really where Roberts will be on this. And it's not likely to be a 6-3 decision, but could they end up with a 5-4? Possibly. We'll see. I will say that as much as we look at the last Supreme Court term as one in which the court clearly put a target on the administrative state through overruling Chevron deference, through the Jarkizi case that held that the Seventh Amendment precluded the Securities and Exchange Commission from using its own ALJs for civil fraud cases. There was actually a case that could have been really extreme, that could have upended the Federal Reserve sources of funding, and the Supreme Court didn't buy that in a 7-2 decision. The CFPB versus Community Financial Services Association case, where the lower court had held that the funding of the CFPB through bank-collected fees by the Federal Reserve was in violation of the Appropriations Clause, but the Supreme Court didn't bite at that, and they said, no, we uphold that. So we might see the same, some kind of limitation on Humphrey's executor's status as well, and something of it will remain. It's anybody's guess, but it's also very clear that that's what all the conservative groups are targeting right now. And until we get a case squarely before the Supreme Court, and we might, I know there's a case involving the Consumer Safety Product Commission that would challenge its for-cause limitations that's scheduled for deciding whether the court will take it at their conference today. I haven't seen or heard yet whether there's been any decision on whether to take that case or not, but we'll see.
There'll be a lot to see as the Supreme Court term begins next Monday. Thanks so much, Cary. That's Cary Coglianese, a professor at the University of Pennsylvania Law School. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.